Hi class, greetings to everyone. So today I'm going to discuss the rules and procedures for appeals filed before the local board of assessment appeals and the central board of assessment appeals. Okay, so let's start our discussion. So first, let's talk about the rule 1 in general provision. So in section 1, which is the title, so these rules shall be known as the rules of procedures of the local board of assessment appeals and central board of assessment appeals in line with the provisions of section 226 and 230 in chapter 3, title 2, book 2 of RA number 716, otherwise known as the Local Government Code of 1991. And in section 2, the construction. So these rules shall be liberally construed in order to promote their objectives and to assist the parties in obtaining just, expeditious, and inexpensive determination of every action relative to the appraisal and assessment and collection of our real property taxes. And the local board, in part of the jurisdiction, shall have original jurisdiction to hear and decide appeals of owners, administrators of real property from the action of the provincial or the city assessor or the municipal assessors in the assessment of their real properties and from the action of the provincial or city treasurer or the municipal regarding collection of real property taxes, special levies or other real property taxes under the title 2, book 2 of RA number 7160. Next, in section 2, the person who may appeal. So we're going to discuss now the rule 2, the local board of assessment appeals. So any owner, administrator, or person with a legal interest in a real property who is dissatisfied with the action of the provincial, the city, or municipal assessor in the appraisal or assessment of his or her property, they may file an appeal with the local board of assessment appeals of the province, the city, or the municipality where the property is located. A real property taxpayer who is dissatisfied with the provincial, the city, or municipal treasurer decision, action, and inaction on a claim for a refund of illegally or erroneously collected real property tax, including the special levies on real property, may also appeal to the local board as provided in these rules. Next, in this section 3, so the conditions for filing an appeal. So there will be no protest or appeal shall be entertained unless the taxpayer will pay first the real property tax. There shall be annotated on the tax receipt the word paid under protest. Provided, however, that in cases where the delinquency is a 100% of the tax that was being paid in previous years, the taxpayer may choose to post a surety bond in lieu of cash due of the tax which is the subject of the appeal, provided uh, further that the remaining 50% shall be paid and distributed in accordance with the provisions of the local government codes implementing rules and regulations. Next, the section in section 4, no, the appeal period. So let's talk about the time. So, and also the date. So the owner or any owner, administrator, or a person who is dissatisfied with this assessment of his property may file an appeal with the local board concerned within 60 days of receiving the written notice of assessment. So within 60 days. Any real property taxpayer who is dissatisfied with the provincial or city treasurer's decision, its action, and or inaction on his written claim for refund or credit within the metropolitan Manila area or in other location may appeal to the local board concerned as follows. So first, letter A, if the treasurer concerned failed to make a decision within 60 days of the date or receipt by the treasurer's concerned of the written claim for a refund or credit for tax paid under protest. So the appeal may be made within 60 days of the date or the receipt by the treasurer concerned or the said written claim for a refund or credit. Next, letter B, if the treasurer concerned will deny the written claim for refund or credit for tax paid under the protest within 60 days of the receipt by the treasurer concerned, the taxpayer concerned may file an appeal within 60 days of receipt by the treasurer concerned of the said treasurer's decision denying the said claim. Okay, so next in section 5, the parties in the local board. So the real property owner or person who will filing the appeal is known as the petitioner, and the provincial or the city assessor or treasurer or the municipal assessor or the treasurer known as the respondents. So in section 6, grounds for appeal. So any action or inaction of the provincial, city, or municipal assessor in the assessment of the real property, as well as any action or inaction of the provincial, city, or municipal treasurer, either of this body, on the taxpayer's claim for a refund of taxes paid under protest or claim for reduction or adjustment of taxes paid or for tax credit on illegally or erroneously collected realty taxes and such other real property taxes. In section 7, the requisite for filing of appeal. The appeal shall be made by filing a petition under oath with the local board concerned within the reglementary period starting the action of provincial or city or municipal assessor or our treasurer appealed from the ground relying on the arguments to support thereof and the date the petitioner received the written notice of the assessment or a revised assessment or tax declaration within a written notice of the assessment. So the secretary of the local board may assist the petitioner in filing the appeal for the purpose of demonstrating a substantial compliance with the aforementioned requirements. And also in the section 8, the nature of the proceedings before the local board must be conducted solely for the purpose of ascertaining the truth without regard for the technical rules that apply in judicial proceedings. Then in section 9, which is the effects of appeal of collection of taxes. So an appeal shall not prevent the collection of the corresponding realty taxes on the real property that are subject to the appeal as assessed by the provincial, by the city, or municipal assessor. Should be continued, no? And subject to subsequent adjustment based on the outcome of the appeal. An appeal may be heard, but the hearing will be postponed until the corresponding taxes on the real property subject to the appeal have been paid under protest or the petitioner has posted a surety bond subject to the following conditions. So first, the bond amount shall be paid at a prescribed rate in accordance with the section 3 of this rule. And also in the letter B, the bond must be accompanied by a certification from the Insurance Commission stating that the surety company is duly authorized to issue such bond, and also that the surety bond has been approved and registered with said commission, and that amount covered by the surety bond is within the surety company writing capacity. Exceeds the surety company writing capacity, if any, must be covered by reinsurance binder and a certification that the effects must accompany the surety bond. Next, in section 10, the period within which to decide. So the appeal must be decided by the local board within 120 days of its receipt. Following a hearing, the board shall make a decision that is based on a substantial evidence or such relevant evidence on record as a reasonable mind that might accept as adequate to support the conclusion. And the service of decision to parties, where the local board secretary shall furnish the parties to a case each with a copy of the decision of the local board, where the parties are represented by counsel serving the decision to the party. Counsel is deemed proper in service to the party. And for our revision of assessment. So if the provincial city assessor agrees to the revision of the assessment, so all of the things that being required has been passed in the as in the passed into consideration, then he or she must notify the petitioner using the form prescribed for the purpose. So the taxpayer or the owner of the property successfully revised, they should be notified by the authority. And powers and duties, the local board shall have the authority to summon the witnesses because this is for the purpose of determining the truth, administer oath, take these depositions, issue subpoenas, and subpoena duces tecum, and conduct ocular inspections of the real properties in question in the exercise of its appellate jurisdiction. So the local board must hold a hearing on all appealed cases and also to make decisions within the time frames that is being specified by the law. It shall also notify the central board of any new matter or issue that is not covered by these rules and shall submit to the latter any report or information that the central board may require from time to time. Next, the Rule 3, which is the Central Board of Assessment Appeals. So in Section 1, it's stated here the appellate jurisdiction. So the Central Board shall have a sole jurisdiction to hear and also to decide all the appeals from the local board decisions, its orders, and also the resolutions involving a contested assessment of a real property, and also the claims for the tax refund and tax credits, as well tax overpayments. So what may be appealed? So all decisions, the resolutions, and orders of the local board in cases involving are the following. First is the contested assessment of real properties, and also the claims for a refund of taxes overpaid and claims for a tax credit. And also the protest against a special levies may be appealed to the Central Board of Assessment Appeals as prescribed herein. Who may appeal and when to appeal? So any party in a case before the local board who is dissatisfied with the local board's decision A resolution or order may appeal to the central board within 30 days of a receipt of the said decision, the resolution, and order. Next is the time to answer or comment. So the appealee may file his answer or a comment on the appeal within 10 days of receiving it, after serving a copy of said answer and comment of the appellant. So within 10 days. Next is the section 6, transmittal of records and appeal. So the local board that rendered the decision to order appeal from shall transmit to the central board to complete the original records of the case, and together with the transcript of stenographic notes, if any, within 10 days of the receipt of the notice of appeal, or a receipt of the notice from the central board to the effect that an appeal has been filed, whichever comes first. And also the records with the pages that is being numbered from the earliest to the most recent must be accompanied by a certification stating that they are the original and complete records of the case in question. Next, the effects of the appeal on the collection of taxes. So there is an appeal now, and what is its effect? So an appeal does not prevent the collection of the corresponding realty taxes on the real property that is subject to the appeal as being assessed by the assessor in question and subject to a subsequent adjustment depending on the outcome of the appeal. And also the withdrawal of appeal. So in case the appellant would like to withdraw, the appellant may withdraw his appeal at any time prior to the central board's decision by filing a written notice of withdrawal with the central board, which will enter a memorandum on the case docket. The central board shall promptly notify the parties in writing of such withdrawal, and there will be no further proceedings on the appeal, and the withdrawal will have the same effect as dismissal. So the period within which to decide and finality of decision. So the central board must rule on cases that is brought before it on appeal within 12 months of receipt. A central board decision becomes a final and executory within 15 days after the receipt by the appellant or the appealee, as the case may be. If a timely petition for a reconsideration is filed, the decision as modified by a resolution on such petition shall become final and executory within 15 days after the receipt of a copy of said resolution by the appellant or the appealees, as the case may be. And decisions, the orders, and also the entry relative to appeals. So all the decisions of the central board determining the merits of the case that is being brought before on appeal shall be in writing, signed by the members of said board, and filed with the secretary of the board, stating clearly and distinctly the facts and the law on which they are based. The decision or order shall be entered in the book of entries of decisions as soon as it become final, with a notation on the dispositive portion of the decision or order. Then the petition for reconsideration. So if the petition for the reconsideration of central board decisions, the resolution or orders shall be resolved by the central board with a like jurisdiction. An aggrieved party may file a motion for reconsideration within 15 days of receiving the central board's decision and also the resolution as well as the order that is sought to be reconsidered, providing a copy of such motion to adverse party, provided, however, that only one petition for reconsideration shall be entertained. And if there will be opposition, the adverse party may file his opposition to the motion for reconsideration within 10 days from the date he receives a copy of the said motion. And action that must be taken on motion for reconsideration. So here's the steps. The Central Board Secretary shall schedule a hearing on the what called the next motion day for the motion for a reconsideration and the opposition thereto, which shall include all arguments in support thereof. The motion for reconsideration shall be considered, submitted for a resolution by the Central Board upon the expiration of the period that is being specified in the proceedings in section of this rule, unless the board will determines that the oral argument are required, in which case the central board shall issue the appropriate order. So class, for your reference, you may also check your manuals on the real property appraisal and assessment operation. This is in chapter 7. So this is the end of my video lecture, and I hope that you've gained something in this lesson that can be useful, especially in the area of the assessments of your properties. Okay, class. So thank you again for being with me in my lecture, and see you again on my next lesson.